Welcome to the debate. Today, we are undertaking a rigorous analysis of Zachary David Enfield's 2026 paper, Lawless by Merit, Natural Law, Constitutional Betrayal, and the Architecture of Unaccountable Power. We are focusing our discourse on a singular, pretty profound question raised by the text. Does the current American governance, which is characterized by unprecedented executive actions and the post-Dobbs legal framework, represent a systemic, structural rejection of foundational law, essentially amounting to a genuinely lawless state? Or are these actions simply aggressive but constitutionally permissible exercises of positive law? I argue that the evidentiary record Enfield presents proves a systemic severing from both natural and constitutional law, creating a literal architecture of unaccountable power.
If I argue that these actions, though undeniably provocative and, historically aggressive, remain firmly within the recognized boundaries of positive law and institutional precedent.
Let's start with that core premise of lawlessness. Because when you first hear that word, it sounds like partisan hyperbole. But the argument here is deeply structural. The text looks at a documented reality that spans the domestic, the international, and the realm of natural law. Just look at the unprecedented nature of the executive record that's cataloged. We're talking about an administration carrying 34 felony convictions, an $83.3 million defamation liability, and a documented defiance of federal courts in approximately 1/3 of all cases brought against it.
Right, the statistics are striking.
They are. And we are also looking at executive advisory bodies like the Dog Age Initiative, completely bypassing Internal Revenue Code Section 6103. For those who might not spend their weekends reading tax law, Section 6103 is the strict statute that protects private taxpayer data from being accessed without explicit authorization. The argument is that this isn't just an administration testing boundaries. It is a total rejection of the framework, and it extends the profound constitutional paradox produced by the Dobbs decision.
Yeah, and the Dobbs paradox is where the text really bridges executive action with judicial philosophy.
Exactly. By returning the question of abortion entirely to the states, the current legal framework has taken the right to life, which the Declaration of Independence explicitly names as unalienable, and converted it into a conditional state-by-state democratic privilege. The text points out that this creates a logical impossibility under the 14th Amendment. It essentially declares that a fundamental human life is unalienable in Texas, but merely a vote-approved choice in California.
Philosophically, it is an incredibly compelling tension, but I think the analysis critically conflates moral philosophy with positive law. And before we dive too deep into the weeds, let's make sure we define that. When we talk about positive law, we are talking about the statutes, precedents, and rules actually written down and enacted by human institutions. Natural law, on the other hand, refers to universal moral principles that exist independent of government.
The crucial distinction.
It is, because when you view this strictly through the lens of positive law, executive overreach is actually a historical norm in the American system. The system is designed to absorb and adjudicate these exact kinds of tensions. When we look at the executive actions you mentioned, or the international military maneuvers like the Venezuela operation, or even the Supreme Court invoking the 10th Amendment to return power to the states in Dobbs, we are seeing a reliance on established legal mechanisms. We aren't seeing a rejection of the framework itself. More importantly, legal personhood is a positive law determination. Until the state, through its democratic and constitutional processes, explicitly recognizes the unborn as legal persons, natural law arguments cannot simply override the Constitution's reservation of powers to the states.
To insist that natural law dictates immediate federal intervention without that positive law recognition is to invite a complete destabilization of the democratic process.
It's fascinating how that tension between state power and natural rights plays out domestically. But the analysis doesn't stop at the border. It takes this exact same framework of executive preference overriding established law and applies it to international military actions. This brings us to a major point of contention, which is the clash between unilateral executive action and international law. There is exhaustive documentation of covert operations that completely bypassed Article 1 congressional war powers, as well as the United Nations Charter.
You're referring to the Middle East and South American operations from early 2026.
Precisely. Let's look at Operation Midnight Hammer. In January 2026, the executive branch authorized a massive strike using 125 B-2 bombers against Iranian nuclear facilities at Fordow, Natanz, and Isfahan. This was executed without an authorization for use of military force, or AUMF, from Congress. And just days prior, on January 3rd, Delta Force conducted the extraterritorial seizure of Venezuelan President Nicolás Maduro. That is a textbook violation of Article 2.4 of the UN Charter, which strictly prohibits the use of force against the territorial integrity of any state. And here is why that matters domestically. Article V of the U.S. Constitution clearly states that treaties are the supreme law of the land. So violating the UN Charter isn't just an international faux pas, it is violating our own domestic constitutional hierarchy. Substituting executive preference for the legal framework itself is the very definition of lawlessness.
I come at it from a different way. We have to look at how the judiciary has historically handled these exact scenarios, because they aren't actually new. The text strongly criticizes the Maduro operation, but the administration's legal defense for that seizure is entirely recognizable within our jurisprudence. We can look directly at the Supreme Court precedent in United States v. Alvarez-Machain from 1992.
The doctor who was kidnapped in Mexico by the DEA?
Exactly. For the listeners, Humberto Alvarez-Machain was a Mexican physician indicted by the U.S. for participating in the torture and murder of a DEA agent. When Mexico wouldn't extradite him, the U.S. essentially hired bounty hunters to kidnap him and bring him to Texas. The Supreme Court ultimately ruled that it doesn't matter how you got to the courtroom. The United States courts retain jurisdiction to try defendants even if they were seized abroad unlawfully. So the legal system explicitly allows for the trial to proceed, regardless of the international seizure's mechanics. Furthermore, we have to acknowledge that consequentialist outcomes often force executives to act aggressively within their inherent Article 2 powers as commander-in-chief. Think about Operation Midnight Hammer. Preventing nuclear proliferation in Iran, stopping an existential threat before it fully materializes, is a profound responsibility. The executive branch frequently has to navigate a dangerous, fast-moving world where waiting for congressional deliberation could result in a catastrophe. The actions are highly aggressive, yes, but they operate within a recognized, centuries-old tradition of executive prerogative.
I see why you think that, but let me give you a different perspective on the long-term cost of that logic. Relying on Alvarez-Machain is a massive category error by the administration. That precedent only established that a court has the jurisdiction to try a defendant once they are brought before it. It explicitly did not establish that the international kidnapping itself was a lawful act. In fact, the Mexican government vehemently condemned the Alvarez-Machain seizure as illegal, and the diplomatic damage was severe. Acknowledging the illegality of a seizure method while laundering the fruits of that illegality through procedural acceptance in a courtroom does not magically make the original act constitutional. It just means the courts look the other way.
But the courts looking the other way is in itself a recognized procedural mechanism. It's institutional tolerance.
But tolerance of a breach is still a breach. And regarding the consequentialist defense for Operation Midnight Hammer, a strategically correct military decision made without constitutional authority remains an illegal act. The War Powers Clause does not contain an exception for good intentions or preferred outcomes. If we accept the premise that the ends justify the means in military strikes, we eliminate the foundational principle of sovereign non-interference. We completely nullify the constitutional requirement for congressional deliberation.
That is a compelling argument, but have you considered that the Constitution itself is designed to be a living, procedural document rather than a static moral treatise? It is built to adjudicate competing interests, not to enforce a singular moral absolutism. And this transitions us perfectly back to the Dobbs paradox you raised earlier. You argue there is a tension between the 10th Amendment, which gives powers back to the states, and the 14th Amendment's guarantee of life and due process. But applying natural law directly into secular governance is inherently problematic.
How so?
Because the Supreme Court correctly applied the 10th Amendment in Dobbs precisely because the text of the Constitution is silent on the specific issue of fetal personhood. Without a constitutional mandate defining who qualifies as a person, powers are rightfully reserved to the states to figure it out democratically. Positive law must define legal categories. Without a clear positive law definition of the unborn as persons, the 14th Amendment's Due Process Clause simply cannot be applied to them. The court didn't create a logical impossibility, it resolved the highly volatile jurisdictional dispute by returning the power to the democratic process.
But the counter to that is that the democratic process fundamentally cannot resolve a question of unalienability. The Declaration of Independence, which provides the philosophical foundation for the Constitution, roots our rights as pre-political. We are endowed by our Creator, not endowed by a state legislature. Furthermore, the text brings in biological science, specifically the documented zinc spark at the exact moment of fertilization, which establishes the initiation of a biologically distinct human organism. The 14th Amendment plainly says no person shall be deprived of life without due process, and there is a devastating historical parallel presented here, which is the Dred Scott decision.
Ah, yes. The antebellum comparison.
It's incredibly relevant. Antebellum positive law did not recognize enslaved African Americans as legal persons either. But that positive law failure did not negate their natural law personhood. If we accept your premise that positive law is the final ultimate arbiter of moral status, then abolitionist arguments prior to the Civil War were legally irrelevant. They were just complaining about a jurisdictional dispute.
I'm sorry, but I just don't buy that. Let me tell you why. The Dred Scott parallel, while emotionally resonant, ignores the actual mechanism of historical correction. The correction to Dred Scott wasn't a sudden philosophical decree from the bench adopting natural law. The correction was the 13th and 14th Amendments. Those were massive, structural, positive law actions passed by Congress and ratified by the states. Until the positive law changes, the state must operate on the definitions it currently holds, however flawed we might find them philosophically.
I'm not convinced by that line of reasoning because of the sting operation analogy, which I think is a central part of this analysis. It exposes a massive definitional incoherence in the state's current posture. Picture this. American courts routinely prosecute individuals for soliciting minors online in undercover operations where the child is entirely fictional. It's an FBI persona in a chat room.
Right. Then there's no physical victim, yet the state aggressively uses its sword to punish the intent to harm that fictional victim. The state is openly acknowledging that the moral character of the act matters independently of whether a tangible victim exists.
Well, that's a standard application of criminal intent.
Right, but look at the hypocrisy. The same state refuses to activate that sword to protect a real, biologically distinct unborn child, claiming its hands are tied due to a lack of recognized legal personhood. Think about how crazy that contradiction is. A legal system cannot coherently hold that intent toward a completely fictional, government-created victim warrants the full wrath of the justice system, but the reality of a biological victim is completely insufficient just because the state hasn't formally rubber-stamped their personhood. It is a glaring logical contradiction that exposes the state picking and choosing when to apply moral weight.
The sting operation analogy is fascinating, and it certainly highlights a philosophical friction. But legally, it conflates statutory criminal intent with constitutional rights recognition. The state prosecutes the predator in the chat room because a specific statute criminalizes the conduct of solicitation, not because the government is granting constitutional rights to the fictional decoy. But let's follow the logic to its ultimate conclusion, which brings us to the moral merit framework and its application to cultural figures.
The Glastonbury example.
Yes. The text uses Kendrick Lamar's performance at the 2022 Glastonbury Festival as a prime example. Lamar wore a diamond-encrusted crown of thorns and chanted for women's rights following the Dobbs decision. The argument is made that cultural icons bear moral merit or moral complicity for the outcomes of abortion policies. But holding cultural expression morally accountable in this way collapses the vital, necessary distinction between speech and direct physical harm. The First Amendment exists precisely to protect this kind of provocative soapbox. If we start assigning moral complicity for legal outcomes based on cultural advocacy, we erode the entire foundation of free expression in a pluralistic society.
It is crucial to clarify that the text is not calling for the legal prosecution of speech. It explicitly notes that the First Amendment robustly and rightfully protects Lamar's performance. The argument operates entirely at the level of moral accountability. As stated in the material, the pen and the sword are one in the architecture of cultural power. But structurally, defending this solely with the First Amendment has a fatal flaw, which is detailed in the text's final addendum.
The incorporation argument.
Yes.
For our listeners, the First Amendment originally only restricted the federal government. It only applies to the states through the 14th Amendment, a legal doctrine established by Gitlow v. New York in 1925. The First Amendment's protection of speech in the context of state action is quite literally a child of the 14th Amendment. Therefore, using the First Amendment as a soapbox to shield advocacy that enables the deprivation of life, the very thing the 14th Amendment was written to prohibit, is logically incoherent. You cannot use a right incorporated by the 14th Amendment to completely undermine the foundational guarantee of that exact same amendment. The soapbox is built on the foundation it has cracked.
That is a clever structural argument, but have you considered that Brandenburg v. Ohio already establishes the absolute limits of the First Amendment? The Supreme Court ruled that speech is protected unless it is directed to inciting imminent lawless action. The law already has a carefully calibrated, built-in mechanism for when speech crosses the line into harm. Expanding this moral merit framework into a universal witness of moral registry risks replacing the Constitution with pure theology. If we dictate that all political and cultural actors are morally bound to a specific interpretation of natural law, regardless of the positive law framework, we are no longer operating a secular republic. We are enforcing a theological mandate from the bench.
That's an interesting point, though I would frame it differently, and so does the text. The universal witness described is not strictly theological, and it certainly isn't sectarian. There is meticulous documentation of a moral convergence across vastly different secular, religious, and indigenous traditions. It cites the Talmud and Sanhedrin 37a, the Bhagavad Gita, the Ubuntu philosophy of Southern Africa, the Lakota tradition of Mitakuye Oyasin, and even strictly secular frameworks like Immanuel Kant's categorical imperative.
It casts a very wide net.
It does, because they all arrive independently at the exact same foundational commitment: the inherent pre-political worth of human life. This convergence proves that the sanctity of life is not some narrow religious preference being imposed on a secular state. It is a civilizational consensus. The current legal framework isn't just defying a specific theology. It is systematically defying the universal witness of human moral wisdom. And by choosing deliberate non-participation, by throwing their hands up and refusing to define the unborn as persons, the state is committing both an abridgment and a deprivation under the 14th Amendment.
But non-participation by the judiciary is often a feature of judicial restraint, not a constitutional violation. The Supreme Court is not designed to be a council of philosophers settling every moral debate. It is designed to adjudicate the law as written. If the text is silent, the court leaves the debate to the legislature. That is the very essence of the 10th Amendment. You view it as a deliberate deprivation. I view it as a system functioning exactly as intended. It protects pluralism by allowing different states to reach different conclusions on profoundly contested moral issues.
But neutrality on the geographic distribution of an unalienable right is not moral neutrality. It is facilitation. Just as neutrality on the state-by-state question of slavery prior to the Civil War was facilitative of profound harm. Letting states decide who gets to be a person is a dereliction of constitutional duty.
The historical parallels are incredibly heavy, but they ultimately reflect the very tension between a perfect, abstract moral framework and the messy reality of governing a deeply divided nation. The positive law framework must rely on jurisdictional precedents and democratic delegation to the states because the alternative, imposing a singular, absolute moral registry from the federal bench, would shatter the republic entirely.
To summarize my position in light of our discussion, the paper presents an unassailable, merit-based architecture of unaccountable power, the documented executive defiance of the courts, the international unilateralism in operations like Midnight Hammer and the Venezuela seizure, and the deliberate constitutional non-participation regarding the unalienable rights of the unborn, all form a systemic rejection of foundational law. The gap between positive law and natural law has widened to a point of profound structural crisis.
And my summary remains that while these executive actions are historically aggressive and the natural law arguments expose deep, undeniable philosophical tensions, the positive law framework is holding. Jurisdictional precedents like Alvarez-Machain, the reliance on the 10th Amendment, and the delegation of contested moral issues to the states remain intact. They are necessary mechanisms for maintaining order in a pluralistic society that does not universally share the same moral baseline, regardless of the historical convergence cited in the text.
I think we can both agree, however, that the source material powerfully illuminates that widening, dangerous gap between positive law and natural law. It exposes profound contradictions in how the state applies its power, perhaps most strikingly seen in that sting operation paradox we discussed, where the state protects a total fiction with its sword while ignoring a biological reality.
Yes, I completely agree with that. The text forces a highly uncomfortable but necessary mirror onto the legal system. The asymmetry in how intent and harm are prosecuted versus how constitutional rights are recognized is a deep tension that legal scholars will have to grapple with for decades.
It truly shows the immense value of examining modern legal crises through these dual lenses, the structural mechanics of the Constitution and the civilizational moral philosophy of natural law. Neither perspective alone gives you the full picture.
Absolutely. It demands that we look past mere statutory compliance and ask what the law actually serves.
For those listening, the intricate arguments bridging the 14th Amendment, international law, and the universal witness offer so much more to explore in the original text. We highly suggest reading the full analysis to weigh the evidence for yourselves. Thank you for joining us on The Debate.
You know, we throw the word lawless around a lot in politics, but what if it wasn't just an insult? What if it was something you could actually prove? Well, that is the really provocative idea at the heart of a 2026 paper called Lawless by Merit. It makes the case that you can demonstrate a presidency is lawless, not as just an opinion, but as a conclusion built on cold, hard facts. And look, the entire argument, the whole thing, really hinges on this one single idea: understanding the massive difference between an opinion and a conclusion that's actually based on merit. The author says once you grasp that distinction, everything else just clicks into place. So let's make sure we've got it. All right, so here's how we're going to break it down. We're going to follow the paper's 5 key steps. First, we'll get into their core definition of merit versus opinion. Then, we'll look at the factual record they lay out across 3 different legal domains. From there, we'll dig into what they call the unalienable paradox, their framework for moral merit, and finally, we'll see if they make what they call an unassailable case. Okay, let's dive right into that core concept. The very first thing this paper does is draw a really bright, clear line between what someone feels and what can actually be documented. It argues that, honestly, most political debates just get stuck spinning their wheels in the land of opinion because we fail to make this one fundamental distinction. So think about it like this: saying, I dislike this president's policies. That's a classic opinion, right? It's all about personal preference. But the author argues listing off documented court verdicts or specific executive actions, that's not an opinion. That's a conclusion you're building based on a public, verifiable record. And this one tool is the key to their entire analysis. Okay, so once the paper sets up that key difference, it moves straight to the evidence. It starts to build its case by organizing a whole bunch of facts into 3 distinct legal areas or domains, creating what it argues is a comprehensive record of lawlessness. First up, we have what the author calls the personal legal record. The whole idea here is simple. You can't really talk about a presidency's relationship with the law without first looking at the documented legal history of the actual person sitting in the Oval Office. And the paper gets really specific here. It points to a public record that includes 34 felony convictions from May 2024, a civil court finding of liability for sexual abuse, a civil fraud penalty of over $450 million, and 17 criminal convictions for the Trump Organization itself. Now, the author's point isn't about any single one of these things. It's about the totality of it, arguing that the sheer scale of these documented court outcomes is something we've just never seen before in a U.S. president. All right. From that personal legal record, the paper then zooms out to the constitutional level. This second domain makes the case that this pattern of behavior also applies to actions taken directly against the U.S. constitutional system itself. And to build this part of the case, the paper brings up a few key examples it claims bypassed constitutional norms. We're talking about 2 impeachments, an analysis suggesting that court orders were defied in about a third of cases, an attempt to change birthright citizenship with just an executive order, and the Soleimani strike, which was a major military action taken without getting approval from Congress as required by the War Powers Resolution. And that brings us to the third and final factual domain, the international stage. Here, the author looks at events they argue were clear violations of international law, which is important because, under the Constitution, international law is also considered part of U.S. law. Here, the paper zooms in on two major events. First, it brings up the seizure of Nicolas Maduro from Venezuela, which it calls a violation of the UN Charter's protection of national sovereignty. Second, it points to Operation Midnight Hammer, the bombing of Iranian nuclear sites, as an act of war carried out without the constitutionally required green light from Congress. Okay, everybody, hang on, because this is where the paper takes a really big turn. We're shifting from the factual record to a deep philosophical argument. This section claims that the legal landscape after the Dobbs decision has created a huge logical contradiction right at the very heart of America's founding ideas. And to get this next part, we have to understand exactly what the author means by the word unalienable. This isn't just fancy language from the Declaration of Independence. No, the paper treats it as a very specific technical claim that a right is absolute. You can't sell it, you can't vote it away, and you can't just pass a law to make it disappear. Why? Because it exists before government is even a thing. And this is where we see the central conflict the paper is trying to highlight. On one hand, you've got the Declaration saying there's an unalienable right to life. But on the other hand, you have the legal reality after Dobbs, where that very same right is basically up for grabs, decided state by state. The author's point? Logically, both of these just can't be true at the same time. Yeah, this quote from the paper really just lays it bare. The argument here isn't about simply disagreeing on policy. It's about a logical impossibility. I mean, how can a right be unalienable, meaning it can't be taken away by a vote if it's, well, being decided by a vote in 50 different states? It's a fundamental contradiction. All right, now we're getting into what is by far the paper's most provocative section. It introduces this idea of a moral merit framework, and it extends the whole analysis way beyond just politicians to include cultural figures too. It's arguing for a type of accountability that goes beyond what's written in the law books. To make this argument work, the paper pulls out a really old idea, the difference between natural law and positive law. Think of it this way. Natural law is like the inherent moral reality of right and wrong, while positive law is just the stuff we've actually written down as statutes. And the author's crucial point is that something can be totally legal under positive law, but still be considered fundamentally wrong according to natural law. And this distinction leads to maybe the most unexpected comparison in the entire paper. I mean, it connects two figures you would absolutely never expect to see in the same analysis. The paper argues that if you look through the lens of natural law, both are participating in a system the paper defines as harmful, just in different ways. The executive, by creating the state-by-state policy, and the artist, by using their cultural influence to build support for that same policy. And to really hammer this point home, the author uses this sting operation analogy. Think about it. In a police sting, the law will prosecute someone for the mere intent to harm a victim who doesn't even exist, a fictional victim. The paper contrasts that with abortion, which it defines as actual harm to a real victim, yet it's legally permitted in many places. The author basically calls this a major definitional incoherence in how our legal system thinks. So, after all that, the legal record, the constitutional paradox, the moral philosophy, how does the author tie it all together? Well, this final section is all about weaving these very different threads into what the paper claims is one single, coherent, and ultimately airtight case. So it really boils down to this four-part conclusion. First, the legal claim, a documented systemic pattern of lawlessness. Second, the constitutional claim, a logical paradox that can't be solved in the post-Dobbs world. Third, the philosophical one, that moral accountability applies to anyone who enables what the paper calls harm. And finally, the universal claim, that this entire conclusion is backed up by a universal witness of world faith and moral traditions. And that takes us right back to the question we started with. The paper really puts it to you, the reader. Is a word like lawless just an opinion, just another political jab thrown back and forth? Or, as this paper tries to prove, can it actually be a merit-based conclusion, built on a mountain of documented evidence and a structured argument? It's a heavy question, and it's the one this paper leaves us all to think about,